Being that it is 10:03, I'd like to call to order the subcommittee work session for February 8th, 2022 for House Bill 1454 FN relative to permits for the siting of new landfills. And with that, based on our rich discussion that we had when Representative Tucker was here and presented the bill before the committee, we have decided that we would like to take an additional look and work further with the bill based on some of the concepts that we had heard in committee around various areas of the concept of time to travel. So with that, I'll call Representative Tucker forward and I'll allow her a couple of moments to talk with us and talk about how the changes have come about, and we'll go from there.
Thank you very much, Representative Murray. Is this being filmed?
I believe it's being live streamed, yes.
Yes, I just wanted to make sure that we all knew what was happening.
Thank
I
you.
always like to know.
Yes, thank you.
So what I've done today is I've made copies of the bill that we have, the proponents have amended and then sent to OLS for review, and they made some recommendations, which we accepted. And then in response to the discussion that came up the other day when we made the presentation, when Director Wimsatt was here, we went through and made further changes which we feel are discussable. And I have given copies to everyone in the audience, as well as members of the committee. Maybe not to, is that Representative Bixby? Do you have one that, this has the annotated. Why don't you come and get it? And so I hope that and I did not send this version to Office of Legislative Services because I was afraid they would get bogged down if we kept making too many changes. So my intention was to listen to the feedback from committee members today and see whether you like these words or don't, or other changes. And I gather there may be other people talking too today, and we can hear what they have to say. And at that point, possibly come up with further changes, which then would go to OLS for their assistance. I let our drafting attorney know that, and she wished me well. So that's where I am. I think we have slimmed and trimmed the bill a lot, and that it's a better bill. Representative Bixby made some changes, not only that read more easily, but it seems to me it's important on this bill, more so than other kinds of bills, to have it so that residents of the state can tell what it means. And so the fact that it reads more easily and is understandable is a really important contribution. So thank you for having this work session.
Great, thank you for coming up here. I will first open it up to the committee members here, just so that we all are aware. The folks here have the ability to participate as well as, but these are the only members up here who have a voting capability. Representative Bixby is here as well, but no, he has no voting capabilities. So with that, I'll open it to the committee members, and if you have questions, and we'll go from there. I'll recognize myself for a moment, if I may. So I did have a couple of questions with regard to the original testimony that you had made, I had a chance to review the link that you had provided with the EPA's source water protection area document here. And so I did have a question on the setback time frame. I've noticed in some places and states they have a 6-year setback, some have a 5-year setback, and so for the 5 years, how did you determine that 5 years was what you would prefer? And I know you had made mention to neighboring states that sometimes have more stringent applications.
I think that we were trying to strike a compromise, particularly on the years around a wellhead. There were, as I recall, 2, 5, and 10 years. And so the 5 represented a medium. And we've not seen anything, or Dr. Finkel has not, in his research, which has been quite extensive, found anything that leads us to believe that there's a perfect answer. But that is why we did that. It seemed like a very reasonable amount.
Thank you for taking my question. Do I see Dr. Finkel today? No?
Alas, no.
Okay, thank you.
He is, however, listening to the streaming and is on the other end of a telephone and cell phone and is texting if he thinks he has something to add. And I can read his text in return. If I misstate something, he's ready to correct me.
Representative Homola.
Thank you. I had a question about the boxed adequate and representative on-site field testing. Does that need to be, I understand that it was used to clarify in section B. Does that need to be explained more? Usually when there's descriptive words, adequate and representative, is that an understood, like a scientifically understood two words, or is there?
I think it is. Representative means, of course, it has to be more than one. And we believe that there is a view of our Department of Environmental Services that this will lead to reasonable discussion between the agency and an applicant, and that this is what that agency is to be doing, given the overall guidelines of the law itself if it passes. And the distinction of before, we had some things that caused difficulty and concern on DES's part that required going onto private property. So we've eliminated entirely the need to go onto private property. That's why the on-site field testing is there too. But when I boxed it, or Adam boxed it, or whoever one of us boxed it, we felt that was a discussable. And I have not heard back. I have high hopes that Director Wimsatt can be here today. I sent him, of course, a copy and have not heard back as to any opinions on these boxed areas. And obviously, this is someone who we will want to pay attention to.
Follow up.
And again, the only reason I'm asking is I just wonder who gets to decide adequate. I like to, when we're looking at things, I like to make sure that there's no question when people read that, what that might entail. And I'm wondering who gets to decide what's adequate.
I think it's really DES.
And but based off of this, they will make up what is an
On
adequate.
a case-by-case basis is what I understand.
Okay, all right.
So there's apparently, as you deal with these various topics, the DES deals with, there is back and forth with applicants.
Okay, All right, thank you. I'm just, again, the reason I'm kind of getting to that is I wonder if you have somebody who's trying to do a project and they have a different idea of what adequate means. Are we opening any door for quibbling?
Let me see,
Here.
I think I have this on the second page, on the,
Yep, I see it there, thank you.
in lines 12 to 13. I'll read it just because it is being streamed. We added 3 words, adequate and representative. So the DES would be able to advise applicants to conduct the minimal amount of testing needed to roughly estimate whether the soils and bedrock at the site are very porous or very impermeable. DES has indicated that it would not need to do rulemaking to further define these 3 words, but could work with applicants on a case-by-case basis.
Thank you. Sorry, I should have went straight to there first. Thank you.
Well, the whole point of boxing it was so we would end up discussing it, so you're just right on target.
All right, so my comment is actually not limited to just this specific piece of legislation, but in general, when a statute is set forth for a department to be the, to act on, the department is empowered to make the decisions relative to that statute. So in this case, the department would be the arbiter of what is adequate and representative. But putting those words in gives it a little bit more clear guidance in terms of they're saying, well, if it's going to be representative, and representative is, you're probably aware of this, is in fact a technical term that involves having enough samples to cover the options and the data that's needed. So on a half-acre site, which you wouldn't probably have, but on a half-acre site, 1 test well may be representative. But on a 200-acre site, then clearly you're going to need to have more test wells than that in order to get a representative sample of of what the soil, the hydrological conditions are around the entire area. So by putting that in, it just really clarifies that yes, this is in the purview of the department to establish.
Follow up, if I may. Thank you, Representative Bixby. Representative Tucker, did you have any discussion regarding sort of the 1 mile? So if we're thinking of things in a circle, and 1 mile out and then 5 miles out, when we're talking again about representative testing, is there a requirement for there to be done at a cadence of 1 mile, 3 miles, and then 5 miles, or anything like that? Or is it just, again, to Representative Bixby's point, at the discretion of the department?
I think it's at the discretion of the department and what is considered best practices in the field,
Thank you.
which obviously over time changes.
Thank you. Representative Bixby.
I'd just like to point out that in the draft that with the boxes on it that we're discussing, it does not indicate at any point that the department would have the option of requiring test wells that were not on property owned by the applicant. So essentially there's a distinction made in it between the actual solid waste disposal area, which is going to be probably less than the area that is owned by the applicant. And I would assume that normal hydrological testing would involve doing testing around the circumference of the test area, of the disposal area, probably in that area that's not disposal area, but is sort of around the perimeter. But that's a little bit of an assumption on my part, but I think that
And
if
I'm not
DES were
sure
here,
that,
they could probably clarify that.
I'm not sure that ownership is necessarily the best word to use. It may be that someone has permission from someone or is paid for permission to go on land that someone else owns, that they would intend to buy if it meets the qualifications. And so that's really depends on what the applicant has to prove to an agency that they have the right to seek a permit. And that may or may not include actual ownership at the time that that's done.
Okay,
I just think since this is recorded that it's important to make those minute distinctions.
Thank you. Representative Bixby, one more.
so in this, I guess because the applicant may be not purchasing the land until they have until it's established that it would actually make sense, then it would be a matter of having the right to access.
Yes, I as a reporter, I cover planning board meetings in other towns from where I live and represent. And this is a very typical thing of someone seeking a subdivision to build houses, that they very often go through the process before the developer makes the purchase to make sure that all will work out. And there's legal ways to say that you have the right to go on property and to dig and test and so forth. And that it's all with the owner's permission that this is being done with the understanding that they're seeking change.
I'll recognize myself for another question again, too. On line 14, on line 5, when we're talking about any leak or spill or other failure, I just was curious to know what types of failures that would entail, if we perhaps need to talk about that further.
This is on line 5?
Correct,
That was the word those were the words that OLS suggested. And I think that other failure is sort of an omnibus term, that it would be something that DES considers a failure. But it was, in case it wasn't a leak or a spill, if it was a rip or I don't know what else, but it's to make it so it covers what people would generally agree is a failure.
Thank you. Is there anybody from the department here today? Great. Representative Comtois.
Thank you, Madam Chair. And thank you, Representative, for taking my question. A couple of things that I was just looking at. It says that the 5-year clock starts when the groundwater becomes first contaminated. So I guess my question is I was understanding that the setback distance would be in effect for 5 years. Not that at any time should any groundwater or any lake or anything be contaminated. But I'm wondering why that's very specific, where it says the 5-year clock would start when groundwater at the landfill site first became contaminated. Just curious about that.
I can,
Representative Bixby?
yeah, I can address that to some extent. So in the bill itself, it doesn't actually say anything about the clock. But the question was having some way of including in the legislation a way of indicating what the point of the legislation was. Why would one bother to track the movement of groundwater in the first place. And another way of dealing with this might be to take it out of, remove it from that location, and then have an introductory sentence or two saying the intent of this legislation is to make sure that if any landfill is, for any landfill that is put in place, that if there were, that there would be a buffer time of at least 5 years if any leak or spill were detected. So the location of that in that sentence is not critical, but the idea is that the way that the point of having a setback is to make sure that if something goes wrong, then valuable resources won't get messed up. And based on previous testimony from Representative Tucker, it seems to make sense that 5 years would be a reasonable amount of time to say, okay, if there is a spill, then in that amount of time, technical methods could be established to deal with the problem. If the spill moved in like 60 days, then there's no way that would be able to be caught. And given the complications sometimes of dealing with technical stuff, even a year or 2 years might not be sufficient to deal with it, but 5 years would be. So the idea is that when we figure out what the setback is for a landfill from a resource, we want to make sure we have time to deal with problems that might occur. And so that's why 5 years. And I think it might actually make sense to move that phrase of any leak or spill or other failure to a different part, simply because the fact that you had a question about it says that it didn't do the job of explaining that's why we're doing this legislation in the first place. So I think perhaps sort of an initial purpose sentence for this section might make more sense.
Thank you, Representative Bixby. Representative Kaplan?
Yeah, this might be a follow-up question for Representative Bixby or for Representative Tucker, I'm not sure. But when you mentioned the 5 years without the clock, any mention of a clock, does that presume that it's the duty of the owner to have some sort of permanent sites for testing to be able to detect any leak? Or is that something that's in the rulemaking? Where does that, what would force the landfill owner to maintain some sort of testing capabilities to know when that clock gets set off?
I think that's all part of the permitting process, is that they agree to conditions. And that's DES's job to make sure that they do. And it's perhaps not as clear in New Hampshire as some places just how often that is. They, again, the department has discretion to set conditions, and they do.
Representative Bixby?
Yes, I kind of wish that there was someone here from DES to clarify this, but I believe that Director Wimsatt mentioned in his testimony something like, they currently have a 4 to 6 month
Yes.
testing period. So I think there already is a requirement for an established landfill to have test wells around the perimeter in order to identify any spill when it occurs.
That's right, but it's not a one-size-fits-all clause so that everybody knows it's every 4 months or every 6 months. My understanding is, from his testimony, is that it's a case-by-case basis.
Thank you, Representative Tucker. Representative Comtois?
Thank you, Madam Chair, and thank you for taking my question again. I'm just reviewing this, and New Hampshire has a lot of water in the state. I mean, every city and town except for one has water, body of water in it. And I understand that it's the greater of 200 feet or X times 5 feet based on velocity. And I'm not a geologist, and I don't understand how the velocity with water flows and everything. But how will this affect getting new landfills into New Hampshire?
Well, I think that we can anticipate with the landfills that we now have operating and an extension to the permit at Carberry, most likely. We really don't have a crisis of immediate need for new landfills. But obviously, we will need some in the next 50 years. It's a huge state, and there is no thought that there will not be sites that could meet this.
Thank you, Representative Tucker. I'd like to also further clarify, it is my recollection as well that your bill and the subsequent amendment would not affect any already existing in operation landfills who may seek permitsure
That's right.
for expansion?
That's right. I think it's on line 7. Nothing in this paragraph shall be construed to prohibit the expansion of any landfills that are in operation at the time this act takes effect.
Thank you. Is Representative Kaplan?
This is just a curiosity question. In the course of your research, I know this is not retroactive, this bill, but the existing landfills in New Hampshire, how many of them would meet this requirement in your legislation, do you know?
I don't. Carberry is the very best example. I'm really I live in a town of Randolph and represent it. It's a member of the consortium the municipal consortium that runs Mount Carberry, and I've toured it a couple of times and been, very impressed. But the tremendous amount of clay and the number of years they have shows that they found absolutely a marvelous place to put that. And there are undoubtedly other such sites in New Hampshire.
Thank you.
Thank you.
Excuse me, I'll recognize myself for a moment. Is there, in your estimation, anything that's limiting the ability for a landfill, if it were cited and there were a failure of some sort and the time to travel is implemented, is there anything in your estimation that the landfill operator already has currently in place that would work in conjunction with this for monitoring, protection, remediation?
The state is monitoring. My understanding is, and it could be faulty, is that, again, if something goes wrong, there's a relationship between DES and the operator where they have to come up with, the operator has to come up with a plan, and then it has to be approved by DES before it's implemented to make sure that it is state-of-the-art remedy. And this, again, is a case-by-case. This is an agency operator matter in which, that's true of all remediation projects. And I think we're going to see this play out with all kinds of issues in the state with other, with chemical and other pollutants, in which people are trying to figure out just what is most effective and will remedy the problem that's been identified.
Thank you. Representative Bixby.
Yeah, I'd just like to comment on something that we haven't touched on yet. The original had the phrase shallow or deep groundwater, and the page with the recommended revision with the boxes has that changed to overburden/till and bedrock. And I think that's a significant improvement because it really clarifies what the physical characteristics of the different levels are. So I feel that revision makes it much clearer and should work.
So I brought a little graphic.
Yes. Is this the same one that you emailed to the committee, Representative? Great, thank you.
It comes off a poster in this.
Great, thank you very much. I'll submit this to the clerk for the record. You're welcome. Yes, I
I
had,
don't have a color printer, so I put where it should be blue, and
I am just locating mine here. So yes, I see in your, in the schematic cross-section that you provided to us, that it is talking about the various types of rock, till, clay, and obviously even granite here in the granite state, and how that water can change, that soil can change the groundwater flow based on the density of the soils. And I believe that that's what this table is trying to show, correct? Is that it's going, you have shallow wells being dug and then deeper ones
Right.
to address those cross-sections in
for
the,
the going down to the bedrock,
correct.
and the
Thank you.
fractured bedrock or non-fractured.
Thank you.
And there's no question that this is the kind of wording which we'll certainly want Director Wimsatt and others' expertise to make sure that we all understand what it means exactly. But it seemed clearer than deep and shallow. And that really is, this is the feedback we need to know whether it is clearer.
Representative Kaplan?
Yeah, I mean, just along those lines, Representative Tucker, is there, I know you probably don't have the answer to this, but it would be good to know, is there any intermediate layers where the speed of groundwater flow could be faster than the overburden or the bedrock? Is there an intermediate layer that they need to be concerned about as well? So it would be good to know that.
Well, I think this is where DES, this is already part of the applicant's process. So they have a lot of experience with test wells.
One thing that I had been looking at sort of as a guiding document of sorts is the EPA's delineation of source water protection areas, and it seems like you had referenced that a couple of times. And I did have some questions about whether or not we are working with other local and sort of regional entities like cooperative extensions or anything of the like that would be used to help monitor situations in areas. It was mentioned in the EPA document that that is one strategy, so that might be a question for Director Wimsatt. And I was just curious as far as continual monitoring or anything like that, if that is something that is being done.
Well, all over the state, we have closed landfills, and they have test wells. I know my little town had what was known as the dump, and that had to be remediated. and test wells put in, and part of our yearly budget, I'm sure this is true all over the state, is to pay for the testing. And it's not inexpensive. And it's going to take place for 50 years. And so all over the state, we have people testing closed landfills, or what used to be dumps, things that never had the lining. And because they don't have the lining, there's more possibility of contamination. And so they are being tested all over the state. So somewhere we could dip into that knowledge. I will find out where we're supposed to do that.
Thank you. Representative Homala.
Yes, thank you. Yes, Rep. Tucker, I just had a quick question. Do you know if, with the currently cited landfills that we have here, is there any data out there that actually discusses groundwater around them as far as looking at X feet per year now? That's a part of, is there any data out there that says, say, this landfill, some of the fastest moving water around that landfill is this many feet per year? Does anything like that, any of that data exist so we can compare that?
Well, we have, I think we've included the Mount Carberry.
I'm
and
sorry,
I think Mount Carberry we have,
okay.
and I thought that was in my original testimony, but I could be wrong.
It might be, and perhaps I missed it. I'm
just-
just wondering if you had that stat or anything like that. Just so, what I'm looking at is I was looking at obviously the 200 feet or X times 5 feet. And I'm just wondering.
Here we go.
Thank you.
On page 3 of a 4-page document,
Of this one?
it was my original testimony. I have copies of it if anyone would like.
Okay, I have it in my bag then.
Okay, so let me just read this. Rather than merely talking about the theoretical, however, I'm going to present 2 actual examples of the years to cause harm concept as documented in Coos County, which of course I represent. The application pending at DES for an expansion of the existing landfill at Mount Carberry provides data showing that contaminated groundwater from the site would take, quote, 60 to 150 years to reach a tributary of the Androscoggin River. The velocity was found to be about 50 feet per year there. It is located in appropriate soils and bedrock.
Thank you.
I have then, I did go on to compare it to the site where the application has been made in Dalton, where the applicant estimated the groundwater flows at that site at 9.5 feet per day or faster. If DES's code setback remains at 200 feet from a water body, then the agency might only have as little as 21 days to notice and respond to a leak at a site where groundwater flows this quickly.
Follow up if I may. I'll recognize myself. So to that end, I also am curious to know, there are many other monitoring techniques in addition to time to travel, and I'm curious to know, would there ever be a time where more than one monitoring technique would be necessary depending on a circumstance? Are you aware of there being multiple methods?
I think that the plus of using this approach is that one of the concerns of DES is that they end up as an agency spending a lot of times on projects that don't go forward. And that's true whether it's Northern Pass, large residential developments, there are all kinds of things where DES is tied up and is spending expertise on projects that don't go forward. So finding a way to sift the wheat from the chaff early was an enormous plus, because naturally there's a financial consequence and having an agency tied up with things that don't go forward. You end up paying the salaries of people who, don't end up with a product at the end. So very much, I think, Dr. Finkel and others were looking for a scientific way to approach this problem that would make it so that DES would be relieved of having to spend a lot of time on projects that were located in places that ultimately would be found to be not suitable or sensible for a landfill site. So that's the big plus of this approach, is it's used elsewhere, it's used in states, it's used by the federal government, and it lends itself to an early appraisal as to whether or not it's a good place to do something.
I'll ask another follow-up around that area. There's the director. Thank you. So my other, to that end, I guess, is it your intent through this piece of legislation then for time to travel to be the initial testing mechanism used? And is that stated clearly in the language that that is the first preferred method with regard to your bill and what you have before us?
Yes, it's a shift from a one-size-fits-all 200 feet that we now have. And it would be the first step. And if you didn't pass, I think in my testimony I called it the exam. If you couldn't pass this, you couldn't get past the SATs. DES has a number of things they look at. Vernal pools, wetlands, all kinds of things. Some more than others. And this really is addressed to the concept of worrying about the groundwater. That is where the greatest potential for harm to water resources lies. And that is why it is addressed. And that is why a lot of time was spent by a collection of people to find something that answered all the requirements that were given by House members and Senate members in previous efforts to find ways to improve the state's siting requirements. And when I heard it, I knew we really had something that was doable, understandable, transparent, and scientific. And it's pretty hard to find something that meets those. So I'm really here, and I'm thrilled to see Director Wimsatt has arrived. I'm here to get feedback from you. We want to polish up this bill. I spoke briefly with the chairman of your committee before the meeting, and he said, there's plenty of time. We can have work sessions. We want to get this right. So I'm looking for feedback, and I'm happy to give way to Director Wimsatt.
Thank you. Thank you, Representative, for your generous time before us and answering all of those questions that we did have. And for those of us here who did have questions, I believe Rep. Homela maybe had one for the director initially.
I was just curious how, in the statement adequate and representative on-site field testing, I was just curious how adequate would be defined. Is that maybe what's the thought process behind that? I'm just trying to find a way. I want to make sure that whatever gets considered it's not setting up a point to quibble with between, say, the potential project and DES. And so that's what I'm just trying to understand is, you know, can you make the word adequate quibble-proof?
Oh, that's fine.
Good morning, Director Wimsatt.
Good morning, and my apologies, I was stuck in another hearing and could not escape, so I came here as soon as I was available. Representative Humla, for your question, I think the language regarding adequacy, actually, forgive me, I just want to take a look at it one more time before I answer your question.
It's here on line 12. Interviews, this is a little blown up.
Oh, so, yeah, I have an amendment, but I don't see that language in there.
That's because this is something that we added.
Oh, this is a point of discussion. Thank you, sorry. Yeah, so I guess, you know, many of the requirements that DES administers have to do with relatively technical scientific evaluations. We rely on applications and materials that are often prepared by professional engineers and professional geologists, and there's a certain amount of back and forth that occurs to evaluate, you know, various requirements and whether or not something that's been submitted meets the standard, if you will. Adequate is a tough word. Representative is a word that we commonly use. The idea is that when you do a sample or when you evaluate something, you're evaluating a representative sample of it. So that's a term that we can work with, I guess. If in this particular example, we're looking at a hydrogeologist doing, you know, probably a soil boring and then looking at soil conditions in the aquifer beneath the proposed landfill site, and then trying to determine, is that representative? Of course, the question is, what scale is it representative on, right? So certainly, if we know through the work that's been done at a given site, that the site is largely sand and gravel of a certain quality, but there are a few clay lenses, then if a hydrogeologist went in and then got a sample from that clay lens and tried to represent that it was representative of the whole site, we would take exception to that. And I think this language would give us the basis to do that. What I do think, it is a little bit, you know, in the context of this bill, we're looking at what's the 5-year travel time of a particle of groundwater, if you will, from the site to a given surface water. And as I testified before, and I just don't want it to be lost in the conversation, New Hampshire's geology is very varied. Our aquifers and the materials in our aquifers are not homogeneous. They're there's sand and gravel and silt and clay and all those things. In certain cases, they're very homogeneous. Maybe, you know, everything from the landfill to the surface water may be a uniform sand and gravel, but in other cases, it may not be. So I do just want to restate the concerns I had before, that if you're trying to evaluate that travel distance, using only on-site sampling to do that is going to have some limitations. It's going to basically, it could bias you one way or the other based on whether the soils beneath the landfill that are representative of the site are more or less permeable than the soils that the groundwater would travel to after it leaves the site. But that's, you know, again, that's the will of the legislature, how it wants to address this bill. But I just, what I don't want to do is make it sound like the agency believes that on-site sampling alone can give you an accurate and precise estimate of travel time, because it's not clear that it can. It may in certain settings, but in other settings it may not. So I just wanted to make sure that folks were clear about that.
Representative Kaplan.
Yeah, I have a similar question about one of the other boxes in the amendment, which is having to do with the different layers of soil overburden / till and in bedrock.
Right.
So the testing would have to take place in both of those layers. Is there any possibility of there being some kind of intermediate layer which would be of concern?
It's
not-
again, going to the sort of heterogeneity and complexity of New Hampshire's geology, there are sites where there's a distinct, what we would all sort of think of as a classic water table aquifer, where it's relatively permeable sand and gravel, and there's a certain water level in that unit, and then you could describe it, pretty simply. Then there could be what we call a confining unit. There could be a layer of clay below that and some tighter, silty, sandy materials beneath that, that are bounded by that clay layer and the underlying bedrock in a way that means that that kind of operates and behaves as its own separate aquifer. Groundwater flow velocities are different, maybe even flow directions are different. That's and potential in terms of the head value. In a confined aquifer like that, you can have vertical upward gradients. You can have any number of things. And then, of course, you have the bedrock aquifer. And that can differ too. There can be some units of bedrock that are very tight, relatively unweathered and unfractured, that don't move much water. Other, superficial bedrock may be very weathered and move groundwater a certain way. But then as you get deeper into the rock, it moves through a fracture system. So, and again, I'm not sure that helps answer your question, but the reality is geology in New Hampshire is very complex. Having said that, I think that when we look at a landfill and we look at how it's sited and constructed, it's reasonable to imagine a release from the liner system and to make a reasonable assumption about what unit that contamination would migrate through and where it might go after that. So there is work that can be done evaluating a specific site that can tell you a lot about how contaminants would move from the landfill site. So I don't want to, by saying that the geology is complex, I don't want to make you think that we think that it's just impossible, that it's anybody's guess. That's not the case. There are things assumptions we can make based on learning a lot about the aquifer and the formation that it's contained in, and knowing where the landfill, how it would be constructed and where it would be in that formation. We can make some reasonable assumptions about the most plausible and fastest groundwater migration options.
Thank you.
Representative Bixby?
Yes, so I'm wondering if the language of adequate and especially representative would allow you to require, in the case that there are, you have, say, as you pointed out, a potential within that overburden, a gravelly layer and then a silt layer or clay layer. Would that term representative allow you to require that the test site evaluate both the gravelly and the denser layer?
I think so. I think what our geologists would do is they'd look at what we know about the formation, and they would make certain assumptions about how groundwater would flow and how contaminants might be transported, and that they would look for the applicant to provide representative sampling and analysis of those portions of the aquifer where they believe that migration was most likely to occur.
Thank you.
Representative Homola? Representative Comtra?
Thank you, Madam Chair. Thank you, Director, for taking my question. Just listening to your testimony, when we're talking about citing a landfill, just so I understand this, and all the complexities of our geography here in New Hampshire, if they're looking at a particular site, based on your testimony, it sounds like you have to do testing also off-site of where that, is that not true, or are you, because you need to see how that groundwater is going to flow. If they have a 200-acre site, and then, there's another parcel, some land next to that, do you have to look at how that groundwater interacts with the groundwater of the site?
Under the current law and rules, there isn't necessarily a requirement to do much in the way of off-site testing. Understanding that the setbacks are numerical. There's not a there's not a requirement to evaluate the groundwater velocity to determine whether a particular, surface water body is going to be impacted under current law.
I am going to also ask a follow-up around that. Would there be any circumstance where off-site testing would be voluntary? You would request that you would like to test an area, or the applicant is also sending that when they're providing the application to you folks? Because you do state that it's not in statute to require the off-site testing, is there a mechanism that you can seek that outside testing through voluntary means?
Well, if we were evaluating, obviously when we evaluate a landfill application, we're evaluating against the rules and the law that governs our decision-making process. If there were a question that we could not answer adequately, that we felt required some kind of off-site data, then we would ask for it. And I don't want to go too far down a hypothetical, but, if we believed that we needed that information to answer a particular question that we're required under the law to answer in order to make a permit decision, then we would do everything we could to make sure we got that information.
Thank you. Just so folks know, we are running up against a hard stop of 11 o'clock. I'd like to further discuss with our subcommittee work group where we are right now, if we feel we should proceed with another work session, if we've not fully answered all of our questions. And I'd like to hear from you folks. Rep. Stapleton, welcome again. Rep. Stapleton is also on the subcommittee work session. So I turn to you first, and then we'll kind of go from there.
I feel like the questions that I had today were answered. I think the clarification of this for the discussion was very helpful. I think it clarified a lot in the original bill, and I think that it also put in some standardized language that eliminates any kind of misunderstandings. And so I'm good.
Representative Bixby, did you have thoughts as well?
Yeah, I've just been sort of making sort of scratch notes here on what we could have as a preamble sentence to clarify the purpose of the section, so that we can move that of any leak, spill, or other failure away from the middle there, and make it clear that this is the purpose of this section is to prevent to make it possible for remedial action to take place if there's in the case of a failure.
So at this time, then, would the motion then be to continue?
I don't think we need a motion.
Oh, thank you. Would you also like to continue working on this through another work session?
I'm not sure that we need another work session. If I draft this and send it around to the committee, and people are generally agreeable to it, then I think we might be able to just draft an amendment and then have a brief work session before to pass it out of subcommittee before we exec it.
So,
Representative Pearl, Chairman.
Madam Chairman?
That's all right. Madam Chair, if I may.
You may.
I think probably the best suggestion is you guys can, look at some language, and we'll schedule another work session for you to sort of finalize and put your thoughts together. And it doesn't necessarily have to be next week. Again, we've got a bit of time on this because we've got into the month. I think it's March 10th is our cutoff date of getting it out of the full committee. So you've got a little time if you want to sort of think about things, and then we can schedule another work session when you're ready.
So,
Representative Bixby?
So I think we may actually be able to pull this together reasonably effectively, but I think in terms of using our time more efficiently, I'm not as sanguine about coming out of the next session with an amendment that's ready to go. So I think it would make sense for us when it gets around to doing the next, when it comes around to execing, I think we should figure on doing the two that we have not yet exec at the same time. So I think this one probably won't be the rate limiting bill.
Sorry, yes, Representative Tucker, before we,
Somewhere along the line, if you all do your work, if you could then send it to me, I will send it to OLS. Because ultimately, they do have to go over it.
yeah, Representative Bixby.
I think actually what probably makes sense is for the amendment to come out of our committee, so that
Right.
it's essentially signaling that this is the committee amendment.
Absolutely, but
So,
then
so which
someone
means,
that-
which means
we
that.
just need to make sure it goes to
Right,
OLS.
yeah,
I'm new to this.
Yes, so our committee will make sure that it goes to OLS.
Okay, but
And-
you'll send it back to us somewhere
and
along the
w-
line
yeah,
before we
so-
go to OLS?
So before we will do since you're the prime sponsor, we always pay the courtesy to the sponsors of the bill of circulating proposed amendments, including you on that circulation. And then, but we will submit the amendment to OLS.
Representative Bixby, I think I am going to create a second work session out of this. I would like to make sure that we are answering the questions, and if there is anything that we still have for the director, once we review everything here, and if Representative Tucker has any other comments. So I think that's what we will do. Thank you. And so seeing that the time is 11:05, sorry, Mr. Chair, we will continue this. Thank you.
All right, good morning, everyone. We're a little bit late getting going. It's 11:10, but we're going to convene the subcommittee for Animal Protection Subcommittee, and we are here to work on House Bill 1186 relative to companion animals during a declared state of emergency. So this bill we've had a slight work, or a brief work session on it, and this one is so that we can be a little more extensive in what we're looking at. We heard testimony from many of the people that had concerns with the bill about mandating having the animals in the same facility as the people that it could cause issues with hotels or community centers with the compatibility of animals. So I passed out two things. Rep. Gallagher had put together an amendment through OLS 0322H, which I handed out to the committee, and I put some on the back table there for anyone who's interested. And the second one is some language that I've been working with the AKC on, a little bit of different language that sort of addresses the concerns and issues that I think we all heard during the testimony about the trailers and the volunteers and how they're not covered under health insurance if they volunteer. So if it's okay with the committee, I think I'd like to actually work off this language that I gave you to start with. Certainly we can, I think it covers a lot of what Rep. Gallagher was trying to do in his amendment as well. But I think this gives, to me, it seemed to be a little more clear as to what we were trying to accomplish. So if that's all right with the committee, we'll start there, and we'll certainly kind of let it go to whatever you all would like it to be. So if you've had a chance to review the language here that I passed out, again, this is sort of twofold in what it's trying to accomplish. So during a declared state of emergency containing an evacuation order, any hotel or community shelter which shelters evacuated persons shall allow the disaster animal response trailers on site to accommodate any companion animal belonging to such evacuated persons. The key point with that is it's not forcing the hotel to have them in the hotel. And that was a major concern that we were hearing. It's just they would have to provide room somewhere in their parking lot so that in essence the animals and their owners would be on the sort of like the same campus. They wouldn't be in the same room necessarily, but they would all be on the same site. You kind of look at it like a campus. I think what we'll do is just kind of take this in pieces. Is there any thoughts from the committee on that part of the language? Representative Bixby.
I like this idea. I think it deals with my major objection. I'm wondering who is in charge of making those trailers available for the purpose?
So it is my understanding that there are 4 trailers already in New Hampshire. And the second part of this bill deals with the sort of like the emergency response team. They would be the ones manning the trailers. As far as who would be making them there, I would assume that would fall under DHHS, just as in to make sure that just as they're housing the people, they would make sure that these trailers would be available for in a state of emergency, just like they would the shelters for the people. So I assume it would fall under the same purview.
Right. I'd like to get some clarification on that.
Certainly.
Just since one of the things that I think we saw in some of the laws from other states that Mr. Torrey pointed out to us was that there's a certain degree of variation in terms of how that responsibility is meted out in different states.
Mm-hmm.
And I'd like to make sure that there is some way of assigning the responsibility for doing that in New Hampshire, as well as just hoping that there are some trailers.
So if I'm understanding correctly, your question is who's responsible for making sure the trailers are on site?
Yeah,
Is
right.
that accurate?
Who's responsible for making sure they're on site and that they exist and that there's a sufficient number of them?
Yeah, okay. Any further? Representative Plinsky.
So on the topic of sufficient numbers, so there's nothing in here that would say, like, so there's 4 of them right now, maybe there's a half dozen in the future, but we have a big evacuation and there's just not enough of them available. Like that's just a resource issue. There would be no mandate on the evacuation site to take in animals if there was no available trailer. Is that correct?
Correct.
Okay, then I think that's, that
It
works
just
for
would
me.
make, they would have to make the accommodation to have the trailers on site, a place
If
for
they
them.
were available.
If they're going to be an evacuation site, then they'd have to make a spot somewhere on site for these trailers to be.
Right. But there would be no negative repercussions for them if no trailer was available to be put on that site.
Correct. That's the way I read it, yes.
Okay, thank you.
Representative Stapleton.
Yeah, thank you, Mr. Chair. This amount of animals comply with local ordinances there on line 9. Are there a variability of numbers of animals that can be contained by residents throughout our state, or is that a uniform number? Because I know that there are some people who are not licensed for dog shelters, but they have more animals than they're really allowed by ordinances. They just haven't been found out. Any research or background that we've had in the committee and other information, other bills relative to how we stand ordinance-wise in the state on that sort of a thing?
I'm not aware of any research that's been done, at least not in my time here. I think we all know that certain municipalities have limiting restrictions on, well, I do know with chickens specifically, that there are, and I don't know that I'm aware of dogs and cats as far as the municipality is concerned, but they may exist. That's something we could certainly look into. But I think by having that statement in the bill that if such ordinances exist, that we wouldn't be causing a situation where they'd be in violation of that. Representative Aaron.
Question, just a different, something different. I'm wondering, is there somewhere in statute where we define what constitutes an evacuation? I mean, you could be evacuated for a lot of different reasons.
That's a great question. I don't have the answer for it.
Okay.
That might be one we need to look into. Well, I think during a declared state of emergency, in the first place, it would have to be a declared state of emergency containing an evacuation order. So that would have to be part of that state of emergency. I'm not sure, what would you need for a definition on that? Or what would you be looking for? What an evacuation order is?
Well, yeah, I guess in a sense, yes. I guess if it's in an evacuation order, do we have a statute that specifies how an evacuation order is defined, or is it defined somewhere?
I'm certain that it is. Representative Bixby?
Yeah, I don't know what the RSA is, but I know that in order for there to be a declared state of emergency, there really has to be some RSA that allows the governor to declare the emergency. And I think that the way this is phrased here, during a declared state of emergency containing an evacuation order, so that is sort of narrowing what sort of state of emergency it is. So we had a state of emergency for COVID, but there was no evacuation order associated with that.
Right.
So I think what we need to do is find out what the statute that is used to declare a state of emergency is, and then cite that in the language. And
Okay.
I'm pretty sure that Mr. Torrey might be able to help with it.
Okay. Anything for Representative Bonplinski?
So I hate the nitpicking part of this, but I guess it's kind of our job here. So you'd mentioned chickens. I think we all know people who keep chickens in enclosures on their property. Now, they don't tend to keep them in the house, but is there should we and I have to assume there's some sort of issue with keeping chickens in close proximity with snakes and dogs and everything else on a trailer. Is there a need to define this a little closer as far as in a home?
So you'll find that companion animals does give definitions, and chickens can be considered livestock
Oh,
in
okay.
statute. So I only threw that out because I do know that there are communities that limit chickens. I don't know if there are communities that limit companion animals. There very well may be, but I'm not aware of them off the top of my head.
Okay, well,
So sorry, I sort of confused it by interjecting chickens, but
No, you really confused, it really just kind of brought up a
sure.
question for me. So
They
thank
are
you.
livestock by statute.
Okay, thank you very much.
Anything further on this part? Representative Bixby.
Okay, this is really picky, and it's sort of for final drafting,
Mhm.
but the any hotel or shelter, that should be a that. And just so that we don't fail to catch that later on.
Sure. That's why it's always good to have an English major on
And
our
I
committee.
assume you don't want the gory details on what the difference is.
We'll save that for the next work session.
I have two other spots too that need fixing.
That's fine. Go ahead.
There's RSA 21-P:41 VI. There should be also a C after that in parentheses because it's part C that we're referencing there.
I will take you at your word on that since I haven't looked
show
at
it
it.
to you.
That's okay. I'm
And
going
then-
to trust you.
And that's your first mistake. And then on the last line, it says, other animal kept in an enclosure that might typically be found in a home.
Yep.
Okay.
All right, so you've jumped ahead into the other parts. Representative Stapleton.
I was just thinking, on that line 10, other animal kept in an enclosure that might typically be found in a home. Would it be helpful to add the word typically and lawfully found in a home? I mean, the people buying pythons and alligators and who knows what else. And sometimes you only come across these things in states of emergency when public services are at that point. And it's a rarity, but probably should be, and put the message out there that lawful ownership is affirmed.
I understand your point, because somebody could have a Bengal tiger there. But I guess those wouldn't typically be found in a home, but they could be. Okay,
Is it illegal to
we can
have
word,
one?
we can wordsmith that. Okay, so we all set on that first part? Do we want to move on to the second portion of it? We will, Kurt. Come on up to the mic if you'd like. That way the folks who are listening online can hear you. We don't want anybody to miss anything.
So I know that I'm not entitled to speak, so I appreciate the opportunity. I would just say that,
Hey, Kurt, just for the record, why don't you say who you are?
oh, I'm Kurt Ehrenberg. I'm the State Director of the Humane Society of the United States.
Thank you.
We support the intent of this bill. The changes made in your changes, Mr. Chairman, I would say vastly make these two bills very, very different. The language, there are not sufficient, depending on the size of the evacuation, we don't know what that would be, obviously. Depending on emergency, I guess it's DART shelters that you're depending on, I would not necessarily say that in a large-scale emergency would be in any way sufficient. And I would recommend that there be some accommodation to say must allow trailers or another reasonable accommodation, some language like that, because it really would be, you'd be able to do it in one town maybe, in the gym there, but next door would not if they could make some reasonable accommodation in another room or another building. I think that would improve this bill, your language immensely.
So you're suggesting after shall allow disaster animal response trailers, you would like to add or other reasonable accommodations on site?
That would be my, and if I'm not married to that language in any way, because I just came up with it. So, and I'm not a lawyer, so.
Mr. Chair, I think that kind of makes sense because maybe people would want to put up a tent to keep an animal in.
Sure.
That needs to have, maybe not be in a contained building, but maybe needs to have more fresh air, or just something that would even be able to be erected more temporarily.
Okay. Certainly a good point. Thank you for
Thank
bringing
you
that
very
forward.
much, appreciate it.
Anybody else? Certainly anybody in the audience that's here, if you want to chime in, just get my attention. We're happy to have your input. Anything further on this first part before we move on? All right, seeing none, we can always circle back if another thought comes to mind. So the second part, during such emergency, any volunteer trained by the Department of Health and Human Services Disaster Animal Response Team who is assisting evacuated persons and companion animals shall be considered an emergency worker under RSA 21P416C. So the important part of this is, at least from my understanding, I got briefed on this a bit this morning because I didn't quite understand it. Originally from the bill, when they were talking about liability, it seemed to me like we were looking to absolve these workers from having any liability, like if something happened to an animal, you know, that they couldn't be sued for that because animals are property by statute. My understanding is that wasn't the intent. It's more about protecting the person that's doing this, like if they're bitten or, I don't know, could be stepped on or whatever thing might occur that caused them a health issue. So what they're looking for with this, the intent is to protect that person and make them basically provide workers' compensation benefits. It's the easiest way that I could put it. So that if, you know, the person that's trained is bitten by a dog or scratched by a cat and gets an infection, that they have the ability to get the appropriate medical care covered by the state, not their personal health insurance, which they might run into concerns with. So this addresses that, attempts to anyway, at least the way we worded it. Hopefully it addresses that and provides them the protection that they would need, and, you know, and guarantees them the health care that they would need in the event that they were harmed during fulfilling this, being a member of the emergency response team for the animal shelter. Does everybody understand where I'm going with that? Any thoughts or questions?
Yeah, I'd just like to
Representative
point
Bixby.
out that I think that it's important, that I'm glad the language is here, that it's volunteer trained by the Department of Health, so that there is actually some sort of, you know, so we know who we're dealing with.
Yes. Any tweaks that you need to, further tweaks you need to see there? Are we comfortable with that portion of it? Okay. The last portion, the maximum number of animals per family entering the hotel or community shelter shall comply with local ordinances. For the purpose of this section, companion animal means a dog, cat, or other animal kept in an enclosure that might typically be found in a home, or typically or lawfully be found in a home. We'll have to play with that as to how you want to on it, but I'm certainly open to that change. Any further thoughts or comments on that? I think it's fairly self-explanatory. Yeah, Representative Von Plinsky.
I guess my only point might be that a wordsmithing thing, and just maybe those last two sentences make more sense before the volunteering. So like the volunteers should be the last part, because we're talking about the animals in the first part, and we're talking about the animals in the third part, and then the second part is the volunteers. I mean, it doesn't really make a whole lot of difference, but that's what occurred to me when I was reading it.
No, I can see your point. It could flow up there too. Would everybody be in agreement with that? Yes? We'll move that up here.
Okay, I also have a comment.
Representative Aaron.
Thank you. Do we need to specify anywhere here that the owner is responsible for feeding these animals or caring for these animals? who ultimately is going to be caring for these animals in this evacuation situation? I mean, there's obviously going to have to be food provided or bales of hay or something, I don't know, but
Sorry, I'm just getting text in and on this because, so yes, there is prescribed authority for the governor to declare and issue orders. Sorry, that was in response to the earlier part.
oh, I actually do, I had found the section
Okay.
that has to do what constitutes an evacuation, and that's section 4:45, Roman numeral 3, item C.
Mhm, okay.
So I can give you that, and
We can
add that
inject
into
it,
the
yeah.
text as part of, referring to that.
I'm going to go out on a limb here. I think the answer to your question is, I'll have to confirm it, is I believe these trailers would be stocked to appropriately care for the animals that are there. But I'll have to confirm that, okay? Because that is a good question. I don't think there would be a requirement placed.
In
Okay, hold on,
statute.
we're getting it. Trailers have food and et cetera, and are set up for, I know they're set up for medical care too, so they would be stocked to take care of the animals that were there.
Okay, and do we care for purposes of the statute, who is paying for that, or who is?
I think that would be part of the emergency response team setup, just like it would be in the shelter.
Okay, gotcha. Thank you.
Representative Bixby?
Okay, so if we add the bit about other reasonable accommodation,
Mhm.
would that also have that food provision attached to it?
That's a good question, and I could see how that could get dicey. Let me think about that a little bit. We can certainly talk about that. Representative Stapleton?
Do we need a time period? Disaster takes place, these animals are scooped up and put in hotel parking lots, trailers, suitable accommodations. For how long? Are there existing statutes, or, in the case of a flood and the house is wiped out, there's no place to go back for the residents or the animals? At what point does the coverage by state and emergency funds cease and personal responsibility take place?
I think my standard answer with that would be the same as the person in the hotel room, that the animals would follow that same course.
Right.
And I'm certain that there's some type of specifications on that, but I don't know them off the top of my head. But
Okay,
I
yeah.
think the intent of this bill would be to give the animals that same time of care during that evacuation order as the person in the hotel is having,
Thank you.
certainly. So I'm getting updates, that's why I'm stopping here, because Stacy Ober from the AKC is listening in and providing me with some information. She wasn't able to come in today. So donations would come in during emergency via animal welfare organizations too. I guess that's standard protocol, that happens. So that's kind of what I came in with. I'm certainly not trying to discount the work that Rep. Gallagher did as well, but I think this sort of takes his and builds upon it and defines it a bit further. I originally was having a difficult time getting my head around this and the concerns that were raised in testimony, which is why I reached out and asked for a little help on putting some of this together, because I just couldn't seem to figure out how we were going to balance that. But I think having the accommodation to have the trailers there rather than trying to have them in the hotel solves one of the real major issues that I had. Anything else that you all want to talk about or add on, or Representative Stapleton?
Yeah, this is an important bill, an important thing to consider. When I was out campaigning, it was like every fourth house had a pet, dog, animal. And I was actually surprised to the extent of pet ownership and care in our state and in our country. And it got to be, that realization took me to start bringing around milk-bone dog biscuits on my campaign walk to make friends with the dog, and that was good for a vote, maybe, But the number out there, and stores are marketing increasing amounts to pet foods and pet accessories and so forth. So it's a big issue when we have a disaster.
Certainly is, and from my understanding, again, I haven't personally experienced this, but information that was conveyed to me that in many cases, most of the people during an evacuation order will have someplace else they can go, a friend, a family, another town, another state, whatever. They're out of the area that's affected, and a lot of those animals can go along with them. But this will affect a small amount of the community that doesn't have that option. And obviously, the larger the extent of the evacuation, the more people it would potentially bring in. I mean, we're thankfully up here, we're not usually impacted by like large hurricane areas like New Orleans had and things like that. They certainly had an extremely large area that was evacuated. New Hampshire isn't really conducive to having that type of an emergency, but we could certainly have something else. But I think this is a good step toward recognizing that this potential exists, and I think we're making good strides toward getting something in statute to take care of that. And those dog biscuits do make a good emergency snack, too, if you stay out longer when you're campaigning.
Haven't gotten that far yet.
Mr. Chair, I have to just say, my son lives down in Florida, and they had a hurricane that they had to evacuate from. And he and his partner have a pet turtle, rather large one. And they had to leave the area, and as they were going to another place that was out of the hurricane zone, of course, they took their turtle with them. And it wasn't easy to find a hotel that would allow them to bring their turtle inside with them. So something like this is really kind of nice to have.
Definitely. Anything further from the committee before we adjourn for today? I'm thinking along the same lines as what was discussed at the end of the last subcommittee, that we can, I think we're fairly close with this language, honestly, that we can probably wordsmith this, and we'll just have to have a brief work session to go over our final draft and make a recommendation out to the full committee. Representative Bixby.
Yeah, I'd agree, and having gone over this, I'm much more sanguine about the chances of getting something put together in reasonable time. So thank you for the work that you did in advance.
Well, I won't take credit for much of it. I sort of got it onto paper, and again, I will thank Stacy Ober. She's sort of the brains behind drafting a lot of this, and explaining it to me so I understood it, because that was a bit of a challenge this morning. I didn't have a lot of sleep because of snow plowing duties, so I appreciate her patience. All right, so I guess what we'll do then is I'll try and get a draft together making all these changes, and I'll individually send it to you all, obviously, so that we're not having a work session offline, and you can take a look at it, and then on our next work session, we'll take a look at the changes and see if there's anything we need to do. Representative Bixby.
Yeah, I propose that we do the work session after our full House session next week, and not next week, but following that, so that we're not getting a conflict there.
Yeah, I don't think we'll schedule any for next week, since we do have 2 days already in House session. So my feeling is, since we're not under the gun with any of these, that we'll skip next week, and I'll have to check the calendar, but the availability of the room. But typically Tuesdays are available, so I will confirm, and we'll put a notification in the calendar. But I'm agreeing with you that I don't think it should be next week. Anything further? Any further comments from anybody in the audience? Anything you want to add? Well, certainly if you all come up with something that you think can help us in this, please send it along, and we're happy to entertain it. All right, with that then, we're going to close out this work session on House Bill 1186. Thank you all for coming.